You're Marcus Elam? And Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation for burglary of a habitation. I've received an updated pre-sentence report. Has everyone had an opportunity to read?
Okay, pause. This is the moment Marcus knows the spotlight's on him, and not in a good way. He's facing the judge, knowing full well that the last 2 years of his life could be summarized in one word: avoidance. But now, he wants a do-over. Would you give him one?
View that report. Are there any additions or corrections to the report?
No, nothing's been changed.
And it was unagreed. Mr. Lewis, you may proceed.
Judge, this is a situation where it's no doubt that Mr. Elam made several mistakes while he was on his probation, not following up on his obligations. After speaking with him, he's been in custody this length of time here. He is definitely, from what he's telling me, willing and wanting to comply with the court's orders, and feels as though he could successfully complete this probation, given that opportunity. He understands that his mistakes, has definitely been costly and put him in this decision. He understands that's totally on top of him. And
now, from a legal standpoint, this is his Hail Mary. When defendants address the court directly, it's not just a plea for mercy, it's their one shot to prove sincerity. Judges are not easily moved, so listen closely. Is he owning up, or just performing?
And of course, he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Yes, ma'am. I'm sorry for my actions that I did when I was on probation. And if you really, I would like to start over and get back, bury my family, go back to work, bury my mother out, give a bill, and everything goes wrong.
Okay.
And Judge, I'm sorry. I was going to say, Judge, if I may, one of the biggest issues I explained and talked to Mr. Elam about was him not reporting like he was supposed to do over that span of time. And he expressed to me that at that time he was dealing with the death of his grandmother, as far as I think she was a big part of his support system. He does have, I've been in contact, several members of his family have contacted me about him, so he does have a support system there. I think she was a big part of it. And after she passed away, I think he kind of wanted to.
The death of a grandmother can be devastating. But here's the question: does grief justify ghosting probation for nearly 2 years? Let us know in the comments. Does tragedy excuse criminal neglect, or is it just another excuse?
At that point, my understanding is that.
What is the status of the 5 new offenses that are alleged? What happened? So what was the deadly conduct from August of 2023? What was the outcome of those? Or I guess I'm trying to figure out what happened on all of them.
My understanding, Judge, he has cases that are pending in misdemeanor court, but nothing here, Judge, that's going to set as any additional.
And he pled true to the deadly conduct, discharging a firearm, from August 16th of 2023. Anna, can you tell?
I'm sorry, Judge. I didn't look him up after he pled true.
I know. I just want to know if I want to know that. I want to know the evading, the failure to ID from February of this year. I want to know what the status of everything is.
I know those are still pending. He hasn't gone to court on those yet, right? Next door.
Andy Cohen.
Mainly on the.
Now, legally, deadly conduct in Texas is serious. It typically means someone discharged a firearm in a reckless manner. That's not just being around the wrong crowd. That's bullets flying. And yet both charges were refused. Sounds fishy. Keep watching.
The August 16th, 2023 offense dates are the 2 deadly conducts. I want to know what the status of those are.
Which,
And PCs, if you can find them. There's 2 deadly conducts that should be somewhere, somebody should know something about from 2023.
in the obstruction in 2023 that was dismissed. I don't have anything on deadly conduct.
What's the offense date of that one, the 2023?
That 323.
Daily conducts from August of 23 were refused, Your Honor.
Do you have any, I guess if they were refused, you don't have any documentation or a PC
I
or?
might be able to see a reason, Your Honor, for the refusal. I'm pulling that up right now.
Thank you.
Wait, he pled true to something the prosecutors say they likely could not prove. That's not just unusual, it's wild. It raises serious questions about legal strategy, plea, deals, and maybe guilt.
There's not. Just said unlikely to prove. There's only one.
I mean, he pled true to it, so obviously there's that. All right, Ms. Malfino, what's the state's position?
Judge, I'm kind of torn on him. Obviously, the concern is the length of time he absconded. I mean, it wasn't just a month or two. They looked for him for almost 2 years, a year and a half at least. And in that interim time period, regardless of them having been filed or refused or whatnot by the intake division, he has pled true to at least the court standard of having committed all of those new offenses while on probation. Although he has no felony convictions, it looks to me like he ordered him to ISF cognitive in 23.
This part's critical. ISF Intermediate Sanction Facility is Texas's version of a second chance. A structured, strict, short-term lockup to whip probation violators back into line. He was ordered to go, but never did. Why? Because he racked up new offenses? The court might see this as game over.
Mr. Lewis had made mention that he never went. I don't know if they didn't have a bed for him and eventually he timed out of that, or something happened and the new offenses came up and they wouldn't take him.
I think when he had the prior MTRP, I don't know if it was at the new case or the prior MTRP, I'm not sure, but ISF was ordered, but at some point, I guess he timed out or something because he was released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to due to pending